Yeah, and I would make sure that the customer knows that. I'm very forward with my clients, be like, hey, just you are, if you're going to be controlling services, you're going to be sharing the liability with us. And most of us are in this business because sites, property owners, property managers, they don't want to be liable. So as soon as you use that word, they kind of get the picture. They don't want to be responsible. They want to control the purse, don't they? But they don't want to be responsible for any of the consequences. So that's a clear way of sharing that, responsibility with them.
Hey, gentlemen, we have another question. If we can move to that one, is that cool? With Manuel was wondering, and I think this is a really good sort of 360-degree discussion between the three perspectives here. Is there a good way to word clearing of aisles in a contract? What's the best way to charge and or word for that, especially during the day when locations are open and you can't it's not clear, you can't necessarily get to everything at once. Kevin, can you kind of help field that first?
Yeah, I'll start off, and then I'm really curious as to what Brendan and Jared have to say, because the word is in there. But from an operations standpoint, this is a great piggyback off of Chris's question, which is you have these very proactive sites that it's just not possible to clear every inch of the lot, which I'll just throw this out there too, because I know we've talked about it beforehand, ongoing operations or completed operations. So that's a very important part that I'm sure we'll get to shortly. But during that ongoing operations, there needs to be something in the agreement that protects you, because from an operations standpoint, we are not going to be able to get to those aisles. We're not going to be able to get to those parking spaces closest to the door. We're not going to be able to get to everything during the storm. So it would be wise to protect us, saying, hey, during ongoing operations, these are going to be the primary parts that we're focusing on. And I've done that in my contracts where I've had the client come up and say, hey, these are I want them to sign in on this. These are the primary spots that we're going to be focusing on. Let's just say it's a daytime storm. We're going to be focusing on this section, These are going to be our primary points that we're focusing on to keep open. And then that night, we're going to come back and be able to clear, the secondary, places. So when you bring that into the contract, first off, you're getting permission right away. There's no argument during the storm as to why that one section wasn't done. Two, you're now protected because it's an ongoing storm, and you're doing it, in a particular order. And then finally, too, it should also helps your guys out too, because now they're not trying to get in those little itty bitty spots while there's grandma and grandpa walking to the store in front of you.
Yeah, and aisles are where there are cars parked and during a storm is incredibly difficult. I think Kevin just explained it pretty much as well as you can, which is having provisions where you're going to focus on areas you can clear initially, and then having it specify that you can go back to deal with the secondary areas is the best way you can deal with it. Because the reality is, and everyone here knows this, is that there are certain clients or certain people who are just not going to move their cars, who are going to have cars in the way, who are going to have obstructions in the way that are going to make it impossible to, get every flake of snow or every amount of ice off a parking lot during a storm in the first instance. So making sure your contract is clear about what your obligations are in the first instance and when you're required to clean up afterwards is really the best way to handle it.
Yeah, I would concur. I think Kevin hit the nail on the head. Insurance is going to respond in a claim like that situation. And sometimes there's just no way of avoiding things like that where we can't get in between those cars. So that's sometimes why we have insurance. But to avoid that, exactly what Kevin said, we need to have some sort of provision in the contract saying, we are not responsible for this at X, Y, and Z time. And we will use that from an insurance perspective to go back to our carrier and say, listen, this is a claim worth fighting, because here's our contract that states that we are not responsible for this area during this period of time. And that's one where the carrier is not just going to write the check. They're going to say, okay, we have something here. You gave us enough information to fight this battle. So that's the best that we can do.
Jared, do you want to bring up maybe that one slide where you talk about verbiage, or no? Wait till another question.
The ongoing versus completed, or yeah, I mean, if you want to,
Heather, I think there was a slide that Jared had up in regards to different sentences. And it's probably going to be 19 or 20.
And kind of, talking what the main point was going to be of talking about the slide, which we're talking about now anyway. But what I'm seeing a lot of times from insurance carriers lately, I'd say the past few years, is they're removing the completed operations additional insured endorsement and only providing the ongoing additional insured. For snow and ice, most of the time, back one.
19 or 20 there.
Yeah, there we go. So the insurance carriers are doing this for a reason, right? It's limiting their liability. Most of the slip and falls are happening on a completed operations, side versus the on. We pick up, we leave that site, refreezes happen, thaws, that's, there's nobody there to monitor. That's when these claims are happening. And we have to be very careful because we're signing agreements as business owners like Kevin that are stating that, yes, we'll provide additional insured status to the property manager. A lot of times I'm not seeing them differentiate between ongoing and completed. What my recommendation would be, if I'm a property manager or if I'm a contractor and I'm creating a subcontractor agreement, I'm stipulating that you will add us as an additional insured for both ongoing and completed operations. That takes out any ambiguity. It takes out any confusion between was it ongoing, was it completed, and I'm seeing that more and more where I go into prospects of not clients yet, read their insurance policies, and they only have ongoing operations. And I put the language up there. I know it kind of gets a little insurance-y and in the weeds, but basically what it says is ongoing operations is all work, including materials, parts, or equipment furnished in connection with such work on the project to be performed by or on behalf of the additional insured at the location of the covered operation has been completed. So does that mean we leave the parking lot, everything's good? Is that completed? Or is that still ongoing operations because we're coming back to that parking lot afterwards? So it's really a gray area. I mean, I don't know, Brendan, what your thought is, but I just know that, all of my clients have both completed and ongoing operations because we never want to be sitting in a courtroom arguing, was it completed or was it an ongoing operations? Were we coming back to that site because it was a servicing issue, or was it a one and done? We were plowing once the storm was over. That for sure is going to be a completed operations hazard, not an ongoing operation. So just something to really be on the lookout for. That it's scary, but I'm seeing this more and more that carriers are providing quotes with only the ongoing operations additional insured, not the completed operations.
Yeah, and I can tell you that from the way this will play out is that in every state there will be some cases that interpret these terms under certain circumstances, but not necessarily under the specific circumstances of what happens in the situation that you're dealing with. So it may be something, like one of the scenarios that Jared just said, okay, there's a case that says what the answer is, but then there may be a circumstance you face where the answer is different or the facts are a little bit different. And so it can get very messy trying to fight these issues out. And it really does, it really is important that when you're agreeing to, an insurance policy or any contractual language, that you understand, where you're operating, what the law is. And sometimes, unfortunately, and I know no one likes to hear this, it is best to speak to an attorney in the first instance to prevent these problems from coming back. Because by the time something happens, by the time there's an accident, by the time, you're facing a dispute with the carrier about contractual language, it's too late at that point because the contract is already signed, the insurance policy is already in effect, and there's nothing you can do about it other than try to litigate the issue, which nobody wants to do.
Brendan's a lot cheaper before the accident.
That's very true. Very true.
That's that's one of the things, unfortunately, with our industry, insurance and the snow and ice, insurance costs are going through the roof. We know that and we see that. So sometimes we'll see, whether it's less experienced insurance agents just provide a quote and it doesn't have that in there. Nobody's saying, hey, this seems cheaper than what it should be. I want to buy more insurance. But you want to talk to your agent and ask the question, does this include ongoing and completed for my additional insured? And if it doesn't, yes, you likely are going to pay extra to get that completed operations endorsement on there. But like Kevin said, it's cheaper to pay that up front than on the back end when you have no coverage for your additional insured.